Amendment of Forest Conservation Act, Basis, Issues and Concerns. The Environment Ministry placed a consultation paper on amending the Forest Conservation Act of 1980 on 2nd October 2021 for public comments. According to the proposal, deemed forests listed by state governments up to 1996 will continue to be considered forest land. Land that was acquired by railways and the road ministries before 1980, but on which forest came up will no longer be considered as forest. The proposal also mentioned that the amendment would reduce the flow from foreign exchange for import of wood and wood derivatives to the tune of approximately 45,000 crore by encouraging plantations and afforestations. One of the main objectives of the amendment was to clarify the scope of application of the Act. Until December 1996, provisions of the Forest Conservation Act only applied to forests notified under the Indian Forest Act of 1927 or any other local law, and to those managed by Forest Department. But a 1996 Supreme Court judgment ordered that all areas that conform to the dictionary meaning of forest were to be also considered as forests. This is particularly problematic in case of railways and roads. There is land that these ministries own, but they cannot use it without permission from the Ministry of Environment, Forest and Climate Change. And these ministries and these permissions can take anywhere between 2 to 4 years, thus causing the delays. Even plantations carried out along road fall under the category of deemed forest comes under this category. Thus, it cuts off access to road amenities like petrol pumps. This makes the road useless. So, Ministry proposed to remove this provision in the amendment. According to the paper, identification of such land is subjective and arbitrary to some extent. This leads to ambiguity and has been observed to have resulted into a lot of resentment and resistance, particularly from private individuals and organizations. Considering any private area as forest would restrict the right of an individual to use his or her own land for any non-forestry activity. In response, a major concern raised by state governments and the Tribal Affairs Ministry was whether the application of Forest Rights Act of 2006 will be affected based on changes brought into the scope of forest law due to the modifications. Reportedly, Ministry of Tribal Affairs considered the Forest Rights Act and Forest Conservation Act to be two different legislations. The Forest Rights Act is very clear that no member of a forest dwelling, scheduled tribe or other traditional forest dwellers shall be evicted or removed from the forest land under his occupation till the recognition and verification procedure is complete. The Forest Right Law defines forest law as any land falling within the forest area. It includes unclassified forests, non-demarcated forests, existing or deemed forests, protected forests, reserved forests, sanctuaries and national parks. The modifications also propose to raise private plantations on forest land that can be harvested. One of India's voluntary contribution under the Paris Climate Pact is to expand carbon sinks by an additional 2.5 to 3 billion tons through more forest and tree cover by 2030. To achieve it, extensive plantations are needed in all available land outside government forests, the paper said. But to ensure this, there is a need to dispel the apprehension among tree growers that vegetation or tree plantation raised on their private or non-forest lands will attract the provisions of the Forest Conservation Act, the paper stated. The amendments has recently been challenged by Chhattisgarh Kisan Sabha. They think that the amended rules have completely abolished the right of Gram Sabhas, forest dwelling tribal communities and other traditional forest dwellers. Until now, the approval for government's development projects required the consent of each Gram Sabha. This requirement has been done away with the amendments. Therefore, these rules should be repealed immediately. CKS representatives said that such amendments in the rule of Forest Conservation Act will pave the way for private parties and corporate companies to control forest resources. The amended rules read that non-forest lands of other states will be made available for compensatory afforestation, the direct impact of which will be in the form of land displacement of tribals, economically and socially weaker sections, and for whom no provision for rehabilitation and compensation has been made. The CKS leader said that the amendments in the Rules of Forest Act is completely against the constitutional guarantee given to tribal communities and weaker sections, and it is also against the Tribal Forest Rights Act, FRA, 5th and 6th Schedule, Panchayat, Extension to Scheduled Area Act, PESA, and the amended Wildlife Protection Act 1972. These amended rules are also in violation of the Supreme Court's decision in Niyamagiri mining case in the year 2013, they said. They demanded immediate postponement of the implementation of these rules and requested review by relevant standing committee of parliament, among others. Source of information: The Indian Express, Hindustan Times and The Hindu. Thank you.